All right. Good morning, everyone. My name is Sipra Boyd. I'm one of the attorneys at Roberts, Markel, Weinberg, Butler, Haley. Happy to see everyone joining. Thank you so much for being here. As most of y'all probably know, part of our firm's mission is to educate because we think education helps, I guess, just keep associations, management, team members, um, management companies, even your law firms, all of the business partners and the volunteer board members that work together on these associations out of trouble. So education is the key for us, and that's why we appreciate all of you being here today. So we are going to talk about board transition from developer control to owner control today. I'm going to hit both uh, the transition period and discuss this topic as it relates to condominium associations as well as single family associations as well. So let's get started. I think I'm going to try and leave some room at the end for questions. If you have any questions, feel free to put them in the chat and we can run through them at the end. I tend to be long-winded and I'm sorry for that, but we will try and do our best to get through most of this material. And all right, real quickly, again, Zipper Boyd with Roberts, Markel, Weinberg, Butler, Haley. I am one of the shareholders. We represent homeowners associations across the state of Texas. If you or any of your boards are looking for assistance on representation, please don't hesitate to reach out to us. All right, this information that we're presenting today is based on the law as it exists today. Remember that, again, this is for educational purposes only. I know that you guys are all on the battlegrounds out there in the forefront and dealing with lots of specific issues, but facts are important. And so I can certainly try to answer a question, but we need to know kind of the full picture and all of the facts before we give you kind of our legal advice. So if you do have a specific question, please reach out to the association's lawyer. All right, so let's talk about transitions from developer control to resident control. Really, this is mostly focused on what it means and what the difference is between developer control and declarant control period, because both of those have some different meanings. And like I said, we're going to talk about those topics within the condominium association realm as well as the single family realm. So for condos, first, most of you guys that work with your condos should know that there are kind of just historical ways also in the single family realm of controlling the association for as long as possible if you're a developer. And so, let's talk about that for a second. Everyone knows that when a developer purchases property, whether it's an acre or 1,000 acres or whatever, and they envision a subdivision, whether it's a condominium or a single family or a mixed master or commercial, at the end of the day, the ultimate goal is to sell those properties and create a community. And part of that process, hopefully, will result in some type of profit to the developer. Now, there are some kind of fly-by-the-night developers that we don't hear from and they come and kind of go. But a lot of the developers that we've come to work with, they are in the development business for not only making money, but building communities. And they are proud of these communities. And so they want to leave the development in the best position for the residents once the developer is done developing and has made its money and is ready to transition out. And I also know, based on experience with representing developers for, many, many years, that residents sometimes are very frustrated and are ready to have the developer transition control much sooner than probably the developer is ready to. And quite frankly, probably much sooner than the residents are ready for taking over, because they don't really understand kind of the components of what it takes to develop a community, maybe to run a community a little bit better, but develop a community is a very different task. And then you also have to keep in mind, and you have to remind your residents that while building a community and running a smooth and effective community is important for developers, they're also interested in, again, selling lots and getting out of there, at when time allows. And so their goals and their purposes are a little bit different than those people that are eventually going to be those end users in those communities that live there for, 1, 10, 20, maybe 50 years. But because of those different goals that developers have, there are different ways that developers have written into their documents mostly, and now through statutory law, have created time periods for when they control the subdivision. And by control, I mean like really control every aspect of it. They control who's on the board. They control who may be on committees. They control architectural review. They control what the documents say, right? They're the ones that have envisioned this community. And so they get to draft the restrictions that say we want a particular lot size and a particular home size, and we want, nothing but 4-bedroom homes, or we want roofs with particular types of shingles and paint or a certain architectural aesthetic. And so historically, there's been lots of different ways that developers have maintained control. And so we're going to talk a little bit about what that looks like in chapters 81 and 82 of the Texas Property Code. Like I said earlier, the difference between development rights and declarant control period. And when I use the word development and declarant or declarant, however you guys want to say it, I really mean kind of the same entity. It's usually the same entity that buys the dirt and develops the community. In the condominium context, we're going to talk about special declarant rights. That's a big topic. We're dealing with a couple of cases where that's an issue, and it's an interesting issue, and not one that I think is easy to deal with. And then some kind of other considerations prior to transition. All right, so quickly for Chapter 81 and Chapter 82, hopefully everyone that works with condos knows that in the Texas Property Code, there are two main statutes that affect condominium associations. Chapter 81 applies to condominiums whose declaration was recorded before January 1, 1994. That's the key date for Chapter 81 condo associations. And then for our Chapter 82 condo associations, those provisions apply to condominiums that were created on or after January 1, 1994. But, and this is a big but in Chapter 82, when you look at the applicability section of Chapter 82, which is early on in the chapter, there are several provisions in Chapter 82 that we call our retroactive provisions, which means that the legislature said, we want a handful of these to also apply to Chapter 81 condominium associations. I know, crazy, right? Legislature just likes to I guess, have fun with us when we're trying to interpret these laws. But so it's kind of a minefield out there. And I have lots of condominium associations that are Chapter 81 associations, and they are very confused when I start talking about Chapter 82 because they think, well, we didn't adopt Chapter 82 or we weren't created before 1994. And you just have to remind them that that's okay. The legislature expressly said, it doesn't matter when you were created, certain provisions apply to you regardless. All right, for Chapter 81 condominium associations, there's actually really no specific declarant or development control provisions. There are several in Chapter 82, but for whatever reason, the legislature decided that those don't or shouldn't apply to Chapter 81 associations. So for my Chapter 81 condos, what's important for you is that you look at your governing documents. You read those restrictions, the declarations, and sometimes the bylaws, and see what those governing documents say about transition from declarant control period to resident control period. And there can be, different, we'll talk about different language, but it looks different in every governing document. A lot of them talk about percentage of units sold. Some of them talk about a time period, a particular date. And so you just need to look at your documents and probably, chat with a lawyer about what that looks like. So a quick kind of summary about the difference between declarant control period and development rights. And this is actually true for single family associations. And they are specifically defined in both Chapter 81, or I'm sorry, Chapter 82 of the Texas Property Code, which applies to condominium associations, as well as Chapter 209, which applies to my single family and townhome associations. But development rights are a broader, I guess, area of the development rights, and they basically apply or talk about the time frame that a developer is developing the property. And it's really typically not really tied to a particular number of units sold or a particular time frame, like 10 years or January 1, 2033 or something like that. It basically is a very generalized term that means while the developer is developing the condominium project. And during that time, it gives the declarant or the developer the right to add or withdraw real property, create units, common elements, or limited common elements, and then further subdivide units or convert units into common elements. So when you think of development rights, really that term develop is important because it's kind of a generic term that talks about if the developer is still involved in determining what this product is going to look like, they're still not finished. There's not necessarily I guess, an end in sight. They're still trying to figure out, is this going to have 3 buildings or is it going to have 8 buildings? Or they're going to be 100 units or they're going to be 300 units? And so that's kind of a very open-end description of development period. The difference between development period and declarant control period is what I was mentioning before, where there is a specific amount of time that is associated with that time frame, and at the end of that time frame, the developer has to do certain things, and that typically means the developer has to either make sure that 1/3 of the board is elected by the residents and not a developer appointed board member, and it also might involve the developer giving up other certain rights. And certainly, if the developer is required to allow 1/3 of the board members to be elected, then they also lose the authority to appoint or remove them moving forward. And again, that really is, I think, central to the transition from developer control to resident control, because what it does is it gives residents kind of a window into what the developer is doing and the decisions it's making in preparation for transitioning control. It doesn't really give the resident, either the board member or the residents, generally much control over the board and kind of the say so, because when you think about it, it's still, if you're a 3-member board, 2 against 1. But I really think it's a great idea, and it's meant to just provide for this kind of runway or an avenue for residents to learn about what it means to be on the board of an association, and again give the resident a window into what is the developer doing, what have they done, what's the plan, why are they making some of those decisions that they're making, and how does that impact residents. But the development period is usually pretty different than the development control, a declarant control period. So for the declarant control period, as I said, Chapter 82 has some specific provisions that apply, and these apply regardless of what your declaration says. So really important to look at this. And again, for Section 82 or Chapter 82, this provision is not retroactive, so it does not apply to condominium associations that were created before January 1, 1994. And this is similar to single family, but still very different. And so you'll hear this or something similar in a little bit when we talk about single family associations. But it says essentially for the end of the declarant control period, not later than the 120th day after the developer conveys 50% of the units, the developer has to elect 1/3 of the board members. The residents, I'm sorry, have to elect 1/3 of the board members. So again, 2/3 are still developer appointed, and then 1/3 must be elected by actually votes that are not declarant votes. They have to actually be elected by resident votes. And then in the Chapter 82, before the 30th birthday after the conveyance of 75% of the units, and this is interesting. So not even before the developer is done selling all of the units in the condominium association that's subject to Chapter 82, the developer has to actually elect all three or all of the resident directors. They have to allow for the election of resident directors. So what you'll see is that's kind of slightly different in the single family realm. There's not a provision that forces developers in the single family realm to give up all of the board seats upon a sale of 75% or more of the lots in a single family association. Okay. In both of these contexts, whenever the developer is giving up control, whether it's statutory or not, the time frame expires. Usually the developer has the right to give up control at any time before that statutory time period, if it wants to. And usually it can just do it voluntarily with some type of a declarant control period resolution or a termination or things like that. And even when it happens statutorily, upon the occurrence of an event, what we would like to see and what we recommend is some type of a document that memorializes that transition, again, whether it's voluntary or not. But the declarant can certainly, before it's done, selling 50% or a third or 75%, it can transition prior to. So for the developer control period in condominium associations, make sure you're looking at the declaration to see what the declaration says. Again, Chapter 82 is probably what's going to be in control if you're a Chapter 82 association, but if you're a Chapter 81, make sure you're reading your restrictions. Here's an example of a declarant control provision, and this one's a little bit different. It talks about transitioning control or terminating control on the earlier of the 120th day after the conveyance of 75% of the units or 10 years after the first completed unit is conveyed. And so there could be some, I think, confusing, conflicting provisions in the governing documents, but you really need to probably talk to an attorney about, well, this is what our documents say, this is what the statute says, what controls, and which one should we be following. And I'll be honest, it's not as clean and as clear as it could be. We have developers that sometimes are hanging on for longer than they should be, and probably don't realize that they're doing that or are doing that on purpose, and the residents don't realize that they're doing that or are fighting to take control. So that it's a big area of topic and really important to kind of understand the distinction. Again, for declarant control, it probably has some type of a duration. It usually will say that sometimes it's either the earlier or the latter of these two events. And regardless, if you're a Chapter 82 condominium association, there is a specific trigger, and you need to be aware of that because that applies regardless of what your declaration says. And then I think that really important to talk about, because I'm dealing with a couple of cases with special declarant rights, and this is kind of a quirky area in condominium law, but typically when a developer is creating condominium associations, they reserve for themselves special declarant rights. And some of them are these examples: the right to maintain sales offices, the right to maintain signs, the right to, issue licenses or permits or grant easements. And if you think about it, if a declarant has to transition control after 75%, even if they have units still left to sell, then the purpose of the special declarant rights are really meant to be beneficial for the declarant to finish selling their units and developing the community. And so these are written in documents. Typically, this is an example of special declarant rights. And what's important about special declarant rights is they have to specifically also be transferred. So sometimes in a couple of the cases that we're dealing with, the declarant ran out of money, the lender foreclosed, and so a new, I'm going to say declarant in quotation marks, tries to come in and pick up the pieces and finish the development. But what is really important in that context is that if the prior declarant or the lender didn't transfer those special declarant rights expressly in some kind of a document, then the new declarant might not have them, and they might not have the ability to sell the units and completely finish completing and developing the condominium project if they weren't given those rights. And I kind of said all this just a second ago. They cannot be transferred unless there's an instrument recorded and executed by the transferee. There are foreclosure or bankruptcy. If a lender comes in, possibly that's going to impact whether or not a subsequent or successor declarant has any of those rights. And then also the declarant doesn't just get to kind of walk away if there is some type of a foreclosure and bankruptcy. In some instances, both the liabilities and the obligations of what the declarant had, the prior declarant had before whatever was terminated, whether by bankruptcy or naturally through statutory control, the declarant, the successor declarant could end up being burdened with those liabilities and some of those obligations. Okay. Last little bit about condos, and then we'll switch to single families. There are some, again, some provisions statutorily that for resident controlled condominium associations are helpful, because as you can imagine, when a declarant or a developer is in control during the developer control period, they might do things and enter into certain contracts that are beneficial for the declarant. And that's okay. You think, oh, well, that's not fair. Well, it is fair because the declarant is in there to, again, remember, create these condominiums, sell these properties, make some money, obviously create a wonderful community that people are going to want to live in for years to come. But they are known for doing some self-dealing. So a developer might enter into a contract with a developer entity, and that's not necessarily against the law, but a developer might have a landscaping entity or some type of a construction entity, or even if it's not their entity, it might be a contract that they are personally involved in and have a personal reason to enter into for purposes of developing that condominium. Well, Chapter 82 has a specific provision. Again, this is not retroactive, but it says once the development control ends, the association can actually terminate without penalty a contract between the association and declarant if it was entered into during the declarant control period. And so there's some specific provisions about that, but if the declarant was in some contracts with the association, because the association is the declarant, the Chapter 82 does give a little bit of a loophole to get out of those contracts. Some other considerations, I guess, for Chapter 81, mostly condominium associations. If there is a question about declarant control period, that's going to be hard to do under declarant control, but the declarant usually has the unilateral authority to amend the declaration, usually has the authority to amend the bylaws, and then through the transition should be transferring any property that's in the name of the developer entity to the association entity. This is less common in condominium associations because the condominium association typically doesn't own property in a condominium. It's owned in an undivided interest with all of the other common areas. But before the developer transitions, it's really important, especially if they have unilateral authority to amend the declaration, to try and talk to the developer about what needs to be done, should be done. Is there something that we can do that would be easier to do under developer control and prior to them leaving, versus after, when it might take, a majority of the residents or 67% of the residents to amend the declaration or the bylaws, because that happens quite often. And then finally, my last slide about condominium associations. We have associations where the developer has constructed these wonderful condominiums, and then for whatever reason, the windows start leaking or the balcony floors start being torn up and being exposed. Whatever the defect, the construction defect issue is, a few years ago, the legislature came through and said that the condominium association has to actually follow a pretty specific process before the condominium association can sue the developer for construction defect claim. So there is an avenue to do that if your condominium is having construction defect issues. But this is one where you do have to work with a lawyer to make sure you've checked off this list of basically, prior considerations that you have to follow before getting involved in some type of a condominium construction defect claim. This again is Chapter 82, and it's not retroactive, but something else to consider for condominium associations that are going through this transition period. And if the condominium is showing some signs of aging and wear and tear that are unusual, and if the residents, when they get on, are trying to kind of position themselves for some type of construction defect claim. Okay, single family associations. Actually, a lot of what I said in the condominium realm it kind of applies or is very similar. But in terms of single family associations, same concept, right? A developer, when it buys land, it wants to create this beautiful subdivision, and then it wants to sell it. It wants it to be attractive so that it can make a ton of money and sell individual lots. So there are also some historical methods where single family association developers are going to try to maintain control as the community is built out and is sold, because let's say you build out a 100-lot community. Once you've sold to 30, 40, 50 lot owners, it's going to start looking lopsided in terms of who has the majority of the votes. And so one method that developers are able to maintain control as it relates to voting on issues is that they divide voting into Class A and Class B memberships. And you'll see this in a lot of subdivision documents where Class A is the residents, that the residents typically have one vote per lot. And then the Class B membership is the declarant, and the Class B member has usually many more votes per lot owned. They might have 10 or 20, and that gives it the declarant more control over any issues that are occurring in subdivision because they have more voting power. And that's what I'm talking about. One, transitioning or dividing membership rights, and then weighted votes is the way that they control the development period. And then similar to Chapter 82 condominium associations, there's some type of a conversion date that you'll see in restrictions. And this is also now dictated by statute. So we'll talk about that, but usually it's once, 75% or 50% or 25%, some number of the lots are sold, then the declarant has to have an election where residents elect to develop a resident that is not connected to the developer, or 10 years after the date that the declaration was recorded, or after a lot is sold. But it'll have that same language that we discussed earlier, the earlier of or the later of these two events, and then sometimes also voluntarily. Once the declarant control period ends, you will see that the transition of Class B votes that the declarant has those votes transition to Class A single weighted votes. And so the developer kind of slowly loses that voting control. And so in Chapter 209, which for my single family associations, that's what the statute that controls single family home associations and then typically townhome associations. And with townhome associations, you have to be really careful because some townhomes look like they're traditional townhomes, but they, depending on the documents, might actually be written as condominium associations. And there's distinctions on there, which I'll quickly explain. Usually in a single family or a townhome association, the association owns and controls the common areas. Whereas in the condominium context, the association doesn't own any common areas. That, like I said, the owners own the common areas in an undivided interest with all of the other owners, but the association typically maintains the common areas. And that's, I think, what's confusing between townhomes and condominiums is because townhomes look like single family homes sometimes, but the association has some level of control over the exterior of the townhome, whether it's painting or roofs or things like that, which then you think, this sounds like a condominium association because they're maintaining the exterior of the townhomes. But really important to look at the definition of common areas and common elements. In Chapter 209, a few years ago, there again was a distinction made between the term development period and declarant control period. Those are two very distinct terms. And again, like in the condominium context, the development period is just a general term that the developer has a right to kind of facilitate the development of the neighborhood. And that involves, the right to have maybe a sales office or use part of the property for a construction site, but really it's a general term that describes the right to direct the size, shape, and composition of the subdivision. And under Chapter 209, the developer has certain controls during the development period, which are different than the rights that the declarant or the developer might have under the declarant control period. But I know it's very confusing, and I don't know why they use such similar terms, but the definition of development period, again, I'll say this, it's usually not a trigger date or a time frame, like 10 years or 75%. It's usually just during the time that the developer has a right to maintain control of the subdivision. And there's usually not any duration associated with it. So very confusing. And if you're questioning about whether or not the developer still has certain rights, that's probably going to be the distinction in the governing documents. So look at your documents and see if they're, certainly when we're drafting documents now, we are using and referencing the definitions in Chapter 209 to make that distinction. Under the development period, the developer has XYZ in terms of control, and then at the declarant control period, the developer has to do XYZ, which those two can be completely separate items. But look at your declaration and see if there's any language in there. But regardless, there's a statutory provision or a statutory definition for both development period and declarant control period. Here is an example of the term development period, and sometimes the declaration could actually associate a development period with some type of a time frame, but this one has a time frame. The development period will exist for 10 years from the date the declaration is recorded, and then it says, or so long as the declarant or a builder in the business of constructing homes who purchase lots directly from the declarant for the purpose of constructing homes, for the purpose of selling completed residential dwellings. So very general term that says, as long as we're still developing and building and selling, we have certain rights, not all rights. And then in Chapter 209, the legislature came through prior to the definition of the development period and put in a specific definition for the end of the declarant control period. And so again, declarant control period means the time at which typically the developer has to give up some rights on the board. And it's usually not all the rights, it's just a limited amount. Again, it gives the residents some window into what it's like to be on the board, but without really any control of the board. Sometimes there's no, if you look at your documents, sometimes it's not tied to a particular time or duration. Again, it might be connected to the later of two events happening, when the last lot is sold or something like that, or a 10-year period. And then it also sometimes has a voluntary conversion date that the developer can voluntarily just turn over control with some type of written document. In terms of the end of the declarant control period, very similar to condominiums associations, but really kind of still different. Like, remember, at 75% in condo associations, the entire board has to be turned over. In the single family realm, at 120 days after 75% of the lots are sold, only a third of the seats have to be resident elected. So there, like I said earlier, there's not a declarant control termination period in Chapter 209 where all of the residents or where all of the seats on a board have to be turned over to resident control. If the declaration doesn't specify a number of lots that will be built in the subdivision, if it doesn't say 1,000 lots, or if arguably maybe doesn't make reference to a plat with a specific number of lots on it, then the date of the declarant control period is 10 years from the date the declaration was recorded. So there's kind of a safety net there if there's no specific number of lots to be created, because as you may know, declarations, or if they're silent, a declarant could keep in continuing to build and add lots and annex property, and that does theoretically, arguably, again, lengthen the declarant control period. But I do think that there are really some stop measures in place if that does happen, or to allow the declarant to maintain control. At the end of the declarant control period in single family associations, 1/3 of the board has to be elected by residents, someone other than the declarant. So sometimes that's just 1 out of 3. We have a lot of associations, depending on the size, that might want to increase the number of board members from 3 board members to 5 board members. So at that point, in order to get maybe some more residents onto the board, a 1/3 would mean 2 of those 5 directors. But those directors have to be elected by people other than the declarant. So the declarant doesn't have voting rights in this election. It's a resident election. And then depending on what your bylaws say, the election of the directors and what their terms are, it could be a year, every year that a resident must be elected, or for kind of consistency and historical knowledge purpose, it might be a good idea to have that resident on the board for 2 or 3 years, a little bit longer, so that when there's full transition, you've got a director that's got some, again, historical knowledge. There are lots of, in Chapter 209, statutory provisions or carve-outs for what a developer can and can't do during the development period. And quite honestly, I should say what an association has to do while it is in resident control versus development control. And developers, again, because they have this different purpose of building this community and selling lots, they have a little bit more leeway in Chapter 209. If you guys work with post-transition resident control boards, you know that there's a list of 15 items that a board has to consider or vote on in an open meeting and an open board meeting. Well, the sister statute for that in Chapter 209, that is a carve out for board meetings during the development period. Or again, remember that's a different term than the declarant control period. But during the development period, which could be a very long time, the board doesn't have the 15-item laundry list. There's only 4 items: adopting and amending governing documents, increasing assessments, electing non-developer board members or establishing a process for that, and then changing voting rights of members. Those 4 items have to be voted and considered on in an open board meeting. There's an asterisk in my slide because the way the statute is written, there's arguably some type of a loophole for a declarant who is amending governing documents under its authority to amend, so that unilateral right to amend your declaration without needing any type of membership votes. Arguably, the association is not amending or adopting governing documents. It's the developer. And so the developer doesn't technically have to do that in an open board meeting. I don't want to get into the weeds into that. And I think really to the extent that a developer can have open board meetings and do most of its business in the open board meeting, I think that's probably a best practice. But arguably, there's kind of a loophole there versus what the developer does and then the association does. There's another provision that has a developer carve out. There's a provision in Chapter 209 that talks about associations that are entering into contracts with people. And this is kind of your interested director conflict provision that talks about if a person on the board is related to a person that you are about to enter into a contract with, the association is about to enter into a contract with, the association and the board has to go through kind of a process of disclosing that interest, potentially shielding the board member that has that interest, whether it's by blood or marriage. And it has to be usually has to be some type of financial interest. They may not be able to vote on that contract, but as long as that interest is disclosed and they are shielded and they follow this particular process that's in the statute, then the association can enter into a contract with an interested director. There's a carve out in Chapter 209 for an association that's under the development period. Again, that longer general period, the developer can basically enter into contracts for as long as it wants. And it really doesn't have any conditions on entering into the contract. All right. I've got a few minutes left for questions. And so I want to just kind of summarize, and I guess let me talk about one other thing before I end. The elections for either whether it's the 1/3 resident controlled section or when it's time for the developer to completely get out, really you have to kind of be prepared for some of that planning, right? There is a hard deadline that says 120 days after 75% are sold. So you talk with your developers and your residents, your resident controlled director to like well ahead of that time frame. And I know it's fluid because it depends on the market and whether or not the director's going to be able to sell that 75% or hit that 75% sold mark. But you need to start at least a year before that. You need to talk about, well, what does this look like? How many directors do we want? Should we leave it at 3? Should we move it to 5? Do we need to amend our governing documents? What are the time frames for sending out the notice and the agenda for this meeting? A lot of my associations that transition from director controlled to resident controlled, sometimes there's really no interest. Their residents are hard to come by that want to be on the board. And so you got to talk about, well, what does that look like? Do we need to start getting people on committees beforehand and trying to get more interest generated before that election comes up? And having people serve on committees is a really good way to try and kind of it's like a building ground for grooming potential board members. And so you want to start having those discussions with your developer if they're willing to, so that you can talk about a transition that makes sense. And then, sometimes the opposite happens where the residents are really mad at the developer because they didn't put in the one amenity that they were hoping for, the walking trail around the lakes or something. And there's, 30 people that want to run, and sometimes you don't have any issues. But I would start at the very least a year or so before that transition to start talking to the developer about kind of this checklist, the transition checklist. What have we done? What do we need to do? Have we tran- uh, have we transferred the common areas? Have we done enough legwork to kind of build some community support around having directors that would be interested in running, and maybe some board orientation type workshops ahead of that, so that people understand what it means to be on the board of an association, so that you don't get a bunch of people that have no experience, because it is helpful. All right, so remember, for Chapter 80, for my condominium associations, there's and my single family associations, there are two separate definitions for development period and then declarant control period. And I know they're very similar. The development period is a very general term versus the declarant control period usually is associated with lot or unit sales or some type of a year time frame. Always remember that there are differences between 81, 82, and 209. Love it or enjoy so much when a resident gets upset with the board and claims, a condominium association board is not following Chapter 209, or a single family association board is not following Chapter 81 or Chapter 82. You just have to make sure you're working under the appropriate statutory context. And there are lots and lots of specific provisions. So always work with your association's lawyers. It's just a minefield out there. And although associations are not as heavily regulated as MUDs and LIDs and those governmental type entities, we're getting to a point where there's a lot of kind of corporate compliance issues that could get you in a lot of trouble. And so you want to make sure that you are working with your attorneys to make sure that you're following the law. And some developer boards, they don't want to have annual meetings, or they don't want to have monthly board meetings, or they may not want to follow some of the statutory requirements, but you really have to have those conversations and try to get the lawyer involved to help them understand why following what's in the property code is really important. Okay. So I'm going to look at some questions in the chat. I know I've seen some activity, so I know that there are some, but before I move into questions, I want to make sure, again, that everybody understands and appreciates that to us, education is so important. We host these webinars. We will come out to your communities, if we represent you, and do board orientations and workshops. My management teams and companies know that we come out there and we love to do educations. So leave us a Google review. Let us know how we're doing. Give us ideas if you want to see something different, or if you want to see something again, or if you have topics in mind. Always love to hear that. All right, so let's look at my questions. And I do think usually, Kyle, maybe you can help me, but we typically make the PowerPoint available. We also will put the webinar up either on our website, or I think we have a YouTube page. And so you can usually access all of this information in a variety of ways. Okay, let's see, scrolling through. Let's see, here's a question. Are you able to change the percent of lots owned by homeowners from 75% to 90% so the declarant can maintain control for a longer period? So no, the short answer is no. The statutory requirement is it supersedes what your restrictions say, and it is a statutory requirement. You are if you were a developer, you were required to transition control, again, just that 1/3 at 75% for single family, and then all three or whatever, the entire board at 75% if you're a condominium association. What happens when a developer does not turn over all of the areas? I have a community where reserves have not been turned over and are still in developer name and not in good condition. It's been over a year. That's a great question. We really, I've had a slew of these. I mean, I just got one where the developer was getting tax notices from the property tax law firm that these common areas were about to be foreclosed on. And it took a lot of research and legwork, not only to find someone connected to the developer entity because it had been 10 years and the developer entity had been terminated, but to kind of work out, and we're still working out, like who's going to pay the taxes and how do we prevent foreclosure, and is the developer going to be willing to do anything about it and pay some funds? Because as far as the developer's concerned, you've got to remember they're done developing and they're out and they haven't thought about the community. And it could just be a year or two. And if it's a year or two, that's great. It's easier to deal with. But if you're talking sometimes 10, 15 years down the road, that's a lot harder. But that's a question for really for a lawyer. You've got to work with your lawyer to figure out, how do we draft a deed from a terminated developer entity into the association? And kind of the follow-up question of, well, what happens if these aren't being maintained? The association needs to be maintaining them, even if they're in the name of the developer. If they are within the jurisdiction of the subdivision, my recommendation is to go ahead and maintain them, figure out, how to get the properties transferred as soon as possible, make sure that those common areas are nominally valued, because technically under developer control, common areas are not nominally valued. And so they are taxed at a higher rate. So that's a benefit of getting them under the association's name. But it's a tricky issue. And you really, it's one of those transition checklist items that have been missed many, many times. And it's just, whenever a developer's done, they're ready to transition control. And so you got to make sure that you guys are paying attention to that and making sure the developer is paying attention to that. Does the Class B voting rights, do the Class B voting rights expire at 75% lot sold? If you're talking about condominiums, I think typically the voting rights are probably different from who's on the board, right? So the developer might still, under the voting rights that he has, have certain control over the association on certain items that are subject to being voted on by owners. That's different than who's on the board. So that's a tough question for me to answer without really looking at the documents, but it could depend. Is the conversion of Class B to Class A required by law, or it depends on the governing documents? That's a governing document question. There's not, it's related to what I was just saying. That's not really addressed in the law. So that's really a separate issue. We have a lot of condo regimes, single family homes in Austin. Yeah, so I just dealt with one not too long ago where what I was dealing with looked like 4 3-story single family townhomes. I mean, they were separate, no party walls. There was a shared driveway, but it looked like a single family home, but it was developed as a condominium. And you know that because of the documents. And what I'm hearing from my development team is those are a kind of an issue for space. In Austin, the land is at a premium. And so when a developer buys property in, I guess, counties like Austin where space is limited, they might not be able to get that area platted as a single family development. And so they have it created as a condominium association, but they put individual condo homes on it. So yes, that's very true. So make sure you read your documents. Can a POA lawfully revert to developer control after turnover to property owners? If so, what type of governing document language would generally need to be included to revive those declarant control rights? Why a POA that is struggling to obtain the quorum needed to amend its governing documents might view this as a last resort measure. That's hard. I don't, first of all, you've got to find a developer that's willing to get it back involved, which depending on, what their interest is in the community and whether there's still lots or units to be sold, they might not want to have anything to do with it. But it's a good question. It's tough. It's probably very it's probably very hard to do that because if you're having a hard time getting the votes to amend the declaration, it's probably going to require a vote to the declaration to try and convert the voting or to get the declarant voting or the declarant rights provision reignited. I don't know, that's not the right term, but I think you're just in a tough spot with needing resident participation. And I don't know that that's probably the right answer, or even if it's possible. Is there a statute of limitations to seek remedy issues left by the developer? There's always statute of limitations with really any cause of action. What the statute of limitation really depends on the cause of action. With construction defect issues, it's probably 2 years. And with developer like breach of contract issues, it's 4 years. And it's usually 2 years or 4 years from the date that you discovered the defect or the issue or the breach, or you should have discovered the issue or the breach. So it depends on the cause of action. And it also depends on when you discovered the issue. After turnover, is the owner controlled POA deemed a successor or assigned with respect to all rights and powers previously reserved to the developer, or only those expressly transferred in the governing documents? So it's kind of a quirky issue. I would say unless special declarant rights were expressly transferred to the association, those are probably not included in the rights as to the association as a successor or assign. I think the association can be viewed as a successor to the declarant entity, but usually what the intention is for that term to apply to a successor declarant entity, not really the association. And if the declarant wants to give the association some special rights, it should either expressly say that it is, or in the restrictions, it should say something like the developer or the association has these rights, right? We've drafted language where both entities have those rights. All right, I'll take a couple more and then we're kind of out of time. It's 12:29. Two-part question. I'm sorry. Does the HOA have the right to collect unpaid assessments from developer-owned units after control was transitioned to owners? That's very heavily specific on your governing documents. Some developers aren't obligated to pay assessments, but they're obligated to deficit fund. But what that means is sometimes really a question, and whether or not they have deficit funded. And so whether or not they have an obligation to pay the assessments and what rights the association has to collect is going to be dependent on your documents. Two-part question for townhomes. Declarant would like for property management company managers appointed to the board after control period when owners are elected for resident control. I'm not sure I understand. Is this allowed? Their workaround is that the property manager is considered an agent of the LLC. The governing documents say the elected director has to be a member. Yeah, I don't know. I'm not sure I understand that. It's kind of a complicated question, and it sounds like you're talking about professionally managed board or professional board members. I'm not sure. I'm sorry, Elvira, I don't understand that question, but that might be a good one for your association lawyer. What if you, for the past 10 years of development, and the developer is adding more lots? So yeah, so that is a thing where developers continue to add lots and continue to develop the property and annex property. And that is really declarant specific. So look at your restrictions, and it's kind of those are one of those hard things that to get around. I mean, in their mind, we have communities that have been being developed for over 40 years, and that's because they just keep annexing and adding lots, and there's nothing against that, really. Let's see. I think that's it for the most part, and we're out of time. So I want to thank you again. Again, education's near and dear to all of our hearts here at Roberts Markel, Weinberg, Butler, Haley. So let us know how we're doing. Give us more ideas. We're always happy to do these webinars and come out and speak to our boards and management companies. So thank you, everyone. I hope everyone stays kind of dry. Some crazy weather, but I hope you'll have a wonderful afternoon and enjoy the rest of your week. Thanks.